What's up, everybody? It's Stephen A. Williams, president and founder of the creditrepairshop.com. And in today's video, we're going to talk about court summons, but we're going to get into an aspect of it that a lot of people don't really talk about, and that's the options in the thought process that you should consider when being sued by a debt collector or even the original creditor. And what made me think about this video was I had received, actually today probably I reviewed about 10 different court summons. And one thing that is very common now that was not common before the pandemic is that a lot of um, uh, uh, debt collectors or original creditors are doing an initial filing where they're just putting the documents into the court record, but they're not actually paying to have it filed. And the way that you would know if it was filed is you would have a court date. So if you just receive a court summons and it's just like we are going to take you to court and sue you, let me tell you there's a rule that's in the Fair Debt Collection Practices Act that if they say that they're going to sue you, they actually have to sue you. So when they submit these documents like this, they actually have to follow through. But a lot of people don't know that. But uh, in this video, what we're going to talk about is we're going to talk about the thought process that you should be potentially thinking about when you are getting threatened that you're going to be getting sued. Well, more than a threat, they've actually sent, had someone either serve you the documents or sent you the documents. Now, what I always do is I tell people to back up and I want them to think about their financial situation because, and let me give this caveat that I'm not giving you legal advice. I'm not giving you legal advice. I'm just telling you what my thought process would be, let's just put it that way, is that when you have a court summons come to you and you look at it and it's not, you don't have a court date. And let me tell you what they're basically doing when you get one like that. Number one, they're trying to see if they can scare you into doing some type of settlement or scare you into paying it in full or just to, scare you so they don't have to take it to the next step to take you to court. And this is some of the things that they're looking at when they're either communicating with you or even if you're not communicating with them. And I just went over this with a YouTube subscriber. Even if you're not communicating with them, you are communicating with them. And let me tell you how. What they have is there's a subscription that debt collectors and original creditors can pay for with all three credit reporting agencies where they can look at what you're doing in your life. So just like if someone was to run your credit to see if they want to give you credit, a debt collector can actually look at your situation and they can say, well, Johnny is paying on their home. Johnny is paying on their credit cards. Johnny is not paying us, but he's also paying all of these other creditors. So, what is our risk factor? Do we think that if we go ahead with this lawsuit, that we're going to get money? And what they'll basically do is they'll say, we're going to go ahead and go through with the lawsuit because we can see from looking at the credit reports that Johnny is paying a lot of people. He's just not paying us. Now, not to say 100% that they would go through with it. They might want to do more research. They might want to see if a person is employed or not employed. Maybe they're getting unemployment and they're able to pay a certain amount of debt and not able to pay on other debt. There's a whole bunch of things that will go into their thought process. But that's like if you want to look at like a step one, because what they're doing, I've seen enough of these, so I can see the pattern on what they're doing. So what they're doing is they're submitting the documents, doing an e-notice. That's what they call them, an e-notice, where they're putting all the documents in there for the court, but they're not paying the fee to execute to get a court date. So we talked about how they can see how you're living your life, even if you don't communicate with them. Now, what I want to talk about is let's look at different ways that we can communicate with them, ways that you can kind of get some relief and hold things off. Is if you truly have a hardship, you lost your job, there's medical issues going on with you or a family member, whatever it is, write that down on a piece of paper and you could submit that to them just to let them know that you're not disregarding them, that you're experiencing a hardship with your family, and that you would like to keep communications open with them, and that you would only want you only want them to communicate with you in writing. Now, that's what you would do. Now, let me tell you what I need you to add to that if you're uh, being sued by a third party debt collector. And I will talk about options on what you could do if you're being sued by a third party debt collector. But let's just say right now money is very tight and you are being sued. You should send those letters so you can try to hold them off. Send the letters to the plaintiff attorney about your hardship. And if it's a third party debt collector that purchased the debt, you also add a paragraph in there that states that you are not admitting to owing them and list them by name any amount of the money that they're claiming. Now that's letter number one. Now letter number two is, and we're talking about if you don't have the money to have someone do this for you, you respond back to the summons point by point. If you look at the summons complaint, they have these numbers, and it'll be like number one, it could be where they're saying you live at this address. Number two, they can say this is your name. And then they'll get into the money that they're claiming that you owe them. When regardless on which one, if it's an original creditor or the debt collector who purchased it from an original creditor, you have a right to dispute everything about the amount and make them prove by giving you statements, your payment history, complete payment history, all of the items that they're claiming that you charged that they paid for, if it's like with a credit card, interest rate disclosure, everything. If it's a third party, what you would add to that is you would ask for a contract from that third party debt collector that you want proof that you should even be discussing any of this with them other than what they're just sending in a summons. You're responding to their allegations, and part of your response is to ask them, why do I owe you? Where is the contract saying I owe you the money, not the original creditor? Show me and prove to me this total balance that you're claiming that I owe. Give me all of the charges, the payments that I made, everything. The interest rate disclosures, contract with you. And if they try to submit some documents, which they try to do, with a redacted account number, tell them that you want the complete account number, that you're not accepting a redacted account number. What if you had other accounts with that same credit card company? That's not abnormal. Someone could have multiple accounts. You could have paid those accounts, and this could mistakenly be the same account. The last four numbers, I've seen it where they matched other people's last four numbers. You want to see the other 12 numbers if it's a credit card account. So you have the right to do that. They have to provide you that information. In a way, they're giving you a full debt validation of the debt. So that's something that you can do. Now, uh, even though they haven't filed the lawsuit, you still need to respond to the answers. And then if they haven't filed it and you send it to the court, they're probably just going to disregard it because it hasn't been filed. But at least if you send that to the original creditor and to the third party debt collector, though they could at least know that you're not going to disregard it and that this is something that potentially you're going to be fighting, and that when you're sending it to a third party debt collector, uh, they could choose to back down because they're going to say, we bought this with millions of other accounts or thousands of other accounts, and we're just not going to be able to get that information because we bought a huge portfolio and they told us when you buy it, everything that's included is there and don't come and bother us for anything else because they don't get into doing that. They don't want to be sharing information that way. That's actually why a lot of stuff is redacted. So the and then the part about the hardship letter, the reason why I tell you to do the hardship letter if you're not in the position to pay to have your court summons responses written for you is that it could potentially, now this is not 100%, this is just another option that you're throwing on the table where potentially some type of relief could happen, is that when you expressing hardship to them that they believe in it, and if they're looking at your credit report situation and it kind of matches, they can see that you fell behind on everything. You got medical bills, you're basically just paying your electric and your house and maybe a car. They could potentially choose to do a 1099-C debt cancellation. That's where they will report the entire amount to the IRS as income to you, and then you would have to pay uh, that as income, but you can get a waiver if you speak to your tax preparer, or you can look it up. There's a waiver that you'll be able to get where that income will be waived and it won't be added to your income and you won't have an additional tax burden. So, and I see this happen a lot when uh, the original creditor is coming after someone that the law firm is usually already paid a retainer, so they don't really care. They're just going to submit the information to the original creditor and let them make a decision on what they want to do. Original creditor might say, "You're paid, you're done. We're not going to get any money out of this. Let's just do a full write off. We'll do a send that back to us, and we'll do a 1099-C debt cancellation." Reason why a lot of the uh, third party debt collectors don't do a 1099-C is because they bought the debt for pennies on a dollar. So they just feel like, hey, it's worth trying to get some money and then they'll write off the additional on a 1099-C, which I believe is technically illegal because if they paid for your debt, you know, a dollar for your $1,000 debt, they paid $1 for it, and then they settled with you for $500, and then they sent the $500 1099-C to the federal government to get the another $500 write-off. That's, I would think that that's not legal because they didn't pay that. An original creditor actually gave the money. They actually extended the credit, so they have a full loss of that income. So that's what'll happen if you end up getting a doing a settlement. That's just the things that can happen on the end of it. But most of you are in the situation where you don't even potentially have the money to do a settlement, and you want to just try to see what you can do to try to work your way out of it. So that would be the way to either extend it or to get some time to be able to recover. Uh, or if you're trying to avoid bankruptcy or avoid them doing a judgment and getting uh, garnishment, these are some of the things that you can do to try to hold it off. Not to say that every creditor is going to do it that way. Now, we do have a service, and you can either, if you want to get more help on responding to court summons, um, the ones that we would do the pro se defense for are the ones that are third party. This is where a third party purchased your debt. And the way that you would know that is if you look at the summons complaint, it'll say, uh, like it'll have a debt collector's name, and then it'll say either in care of, let me look at this one. It'll say something like uh, the debt collector's name, and then it'll say assignee, and then it'll have the original creditor. Some of the time they don't even put that on there, but it'll have the debt collector's name and then assignee or just a debt collection's name, and you'll know if you had did business with them or not because you'll be like, I never did anything with you. Those are the ones that the pro se defense at least has a chance at being successful with, because they some of the times they don't have all the documentation to prove that you have to pay them specifically, and you can try to get some of their evidence taken out that they use to try to prove that you owe. I have two options. One is where we do the defense for you. Well, we do the setting up the documents. You got to defend yourself. We just get all the documents ready so you can file them with the court, file them with the debt collection attorney, or you can watch my videos and do it yourself. That's only 19 bucks. You can do that. And there's some other free material that I give you. It's with my membership program. You can use that for as long as you want to use it. Refer back to there. There's a lot of good information in there. But the big thing is that you don't disregard this stuff, because a lot of people, what I'm seeing is that they just disregard it. They think it's going to go away. It's not going to go away. And they get fearful, they get emotional. And the only way that you're going to fight getting fearful and emotional is to uh, really just try to fight back. And the way that you fight back is by assessing your situation. Just and you can rewind this video and go over, because I went point by point. If you're at the point where you're unemployed, I told you what to do. If you're, disabled or have medical issues, I told you what to do. If you have money, I told you what to do. So this is really a good game plan, and the biggest thing is that you just don't let it sit there and do nothing. Because if you do nothing, they're gonna do everything to take advantage of you. They're gonna get garnishments, and they're gonna make life even harder for you. So I'm going to be ending the video here. What I want you to do is I want you to subscribe to the channel if you haven't subscribed. Please like the video because that helps with the algorithm. We need that. That helps more people learn about this. Um, if you need help with your court summons response, there's a link below this video. You can do it yourself, or you can watch my other videos here for free on YouTube. I have several where I walk you step by step how to respond to a court summons. If you need help with your credit, please go to the website, thecreditrepairshop.com. If you need your credit reports and scores, because everything starts there. You can look at your credit reports and see how they're seeing you, and you can make a determination. If you were the debt collector and they were looking at your credit reports, how would they think that you're living your life? And that's how you can kind of structure what direction you want to go. Because if it looks like you have money and that they can come after you for it, then you might be more inclined to do a settlement because you just don't want it to go any further. If you are in a bad situation financially, it looks like you could go into bankruptcy, then the hardship letter could work to slow things down and potentially get them to do a 1099-C debt cancellation. All right. Well, I would like to thank everyone for watching. This is Stephen A. Williams, President and founder of thecreditrepairshop.com. Thank you.